I'm supposed to be here for my landlord tenant
Okay, you
case.
should be 436. So, let me know when you're ready to take, or how do you log on? Did you do it from the website or did you dial in the numbers?
I just pressed the link that I was sent.
Okay, so I'm gonna give you the Zoom information. Let me know when you're ready to take down the ID.
I'm ready.
It's 360
Mm-hmm.
436
Okay.
0000.
Okay.
And that's Adam Sabree, my brother.
Okay. Thank you.
You're welcome. Yeah. This is case number 2355267. The people of the state of Michigan versus Kawan Edward Eggerson. Count one, assault with intent to do great bodily harm less than murder or strangulation. The defendant is a habitual offender, second offense notice. This matter is set for an exam.
Good morning, Your Honor. For the record, Aaron Dan for the people, P78733.
Good morning, Your Honor. Nancy Bassett from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Ed Sherson, P number 80549.
Judge, today's the date and times, as the court is aware of the preliminary examination. It was set for 9 a.m. The people are, and I am aware that it is 10:10 a.m. The complaining witness in this case, his name is Alan Rossetto. Alan is a quadriplegic, he is wheelchair bound. It is my understanding that the transportation company was at his home at 8 a.m. this morning, but there was no one available at his group home to actually assist him from getting from his room to the cab company, and the cab company was not able to do that as well. It's my understanding the cab company is en route. Two victim advocates have been in touch with the cab company, and as of about 5 minutes ago, they were about 10 to 15 minutes away. He does reside within the city of Detroit. I do have another couple of hearings this morning, and I know defense counsel is as well. I know defense counsel's position that this exam was set for 9 a.m. Sharp. I am respectfully requesting that this court set this preliminary examination either for around noon, 12:30, 1 p.m. today. I know the court has a busy schedule, and that is at the lunch hour, or adjourn it out to another date, Your Honor. In the interest of justice, and there's good cause for this, Judge, we do have a extremely fragile victim. He is cooperative. He just physically cannot get here on his own.
Your Honor, and I understand Madam Prosecutor's position. However, again, this matter was scheduled for 9 o'clock. We did wait an hour to give this complainant an opportunity to make it to court. It is past 10 o'clock right now, and so I am going to object to the adjournment.
So you said the complainant was on his way.
He is, as I spoke to him about 5 minutes, Your Honor, he's sitting outside on the sidewalk, waiting for the cab company. He had spoken to the cab company about 5 minutes prior and said he was about 15 minutes out. So he is in, I know that he has represented to me that he is ready and able to come to court. We're just waiting for him to get here.
Okay, where else do you have to be?
Pardon?
Where else do you have to be?
I have a hearing with Judge Walker at 11 a.m. That was set for 9 a.m. I requested leave from the court. I know there are two other attorneys that are going to be there at 11 a.m. And I have a hearing with Judge Cox that is also set for 9 a.m.
Okay, I don't want to adjourn, especially because the amount of time it's taking to get the complainant with the here. I can call Judge Walker.
Like I said, I think that I will be here. Judge Walker knows that I'm coming at 11 a.m. I think that defense indicated she had another hearings as well.
I have a doctor's appointment as well, so I need that a month ago.
No. And I mean no disrespect with that, Your Honor.
So.
I can wait, Your Honor.
How many witnesses do you have?
Just one, Your Honor. It's just this assaulting case, just one.
So it should be 15 minutes, he should be here?
I think so.
Okay, if we can, at 11 o'clock.
Yes, Your Honor. So I don't know if he's, like I said, the cab company said 10 to 15 minutes. He's in a wheelchair. They have to load him. I don't know if it's going to be 15 minutes. It could be longer than that.
Nobody, you're not talking to you're spoken to right now. We're in the middle of trying to schedule everything. Okay.
Let's go.
Bro, no walk
Let's go. Stop playing with you,
I
man.
ain't talking with y'all. Walk up on me. I ain't no hoe. What you think this is?
Talking to you.
Man, fuck you, bro. All this soft ass shit y'all doing, cause nigga hand. Oh, I've been to beat the shit out of both of y'all. What's wrong with y'all?
Thank you, bro.
At this time, Judge, I'm wondering if a referral for competency would be in order. I do know there is some indication that the defendant in this case might be schizophrenic. I don't know that for certain, but given the behavior that we just witnessed and what the victim has represented to me about his behaviors, I'm wondering if a competency referral would be in order.
So you've been interacting with the most.
And Judge,
And what I just saw, it's the first thing I saw, but you was no.
Judge, I did have an opportunity to speak with Mr. Ederson, and I did also speak with Madam Prosecutor regarding her concern about competency. I do believe there might be mental concerns. I don't know if it's competency though. Obviously, that's different from competency. You know, mental concern can be different from competency, so I don't. At this point, I just don't know if I can refer him for competency, but I do believe that there are possible mental health concerns.
Well, based off what just happened, he's not ready to, and he's not going to behave, in my opinion, today, for example. We didn't even get to the end of our scheduling issue, and already had an outburst. So I don't think today.
I'm sorry, Judge.
I don't think today is a good day to hold this again, or at least not right now. So I will have to grant the adjournment. The question is when. So today is not going to work. Sure. We don't have anything else waiting.
Thank you.
Sure. Okay, we're back on the record on Mr. Eggerson, Quan Eggerson. There was a sidebar discussion with, both prosecutor and defense counsel regarding, referring Mr. Eggerson to, for competency. And, based on the discussion, I'm going to have a refer. Is that pretty much accurate what we discussed?
Yes, Your Honor.
Yes, Your Honor, and just for clarification, are you going to do competency and criminal responsibility or just competency?
Should we do both?
I think in the interest of time, Judge, knowing that that's coming regardless.
Okay.
Yes, Your
All
Honor.
right, so, I'm sorry, you agree with that?
I do.
So I guess what, 60 days is what the going time is now?
I think that they're a little faster than they were during the pandemic.
Okay. April 19th, the Wednesday.
And this would just be a competency hearing.
Correct.
I'm sorry, Judge, you said April 19th?
Yes.
Yes, Your Honor, that works for the defense.
And for the people, Judge, as well.
Okay, 9 o'clock work as well?
Yes, Your Honor.
That would be fine. Thank you, Your Honor.
Is that going to be via Zoom, Judge, or?
Zoom, yes. Let's do that on Zoom. Okay, so that was unexpected, but we got through it.
Thank you, Your Honor.
Call them up.
Have a good rest of your day.
Thank you, Judge, and happy Valentine's Day to you and your staff.
Thank you. Thank you. Ms. Delsa? Attorney Howell, good morning.
Good morning, Judge. I was just writing you on chat.
Oh,
I'm here because, do you remember that exam I have that was rescheduled? My client, Victoria Wilson, her mother was a defendant, her sister was a defendant, and it was, the complainant was their cousin?
yeah, that's on the 21st. I believe one of the defendants passed away.
Yes, the mother passed away. Her funeral is this Friday, and the complainant, she plans on going to the funeral. She's saying that although she was pressing charges, that the aunt, that mother is her favorite aunt, and she refuses not to go. My client wants to go as well because that's her mother, but she feels like she's going to get violated for being in contact with the complainant, and she's really upset. And I wanted to just get like a court order stating that she would be able to attend the funeral, although the complainant will be there, and she does not plan on having any contact with her, talking to her or anything like that. But they would be in the same room for the funeral and the repast.
Okay, it's gonna have to go both ways. Complaining witnesses who can't be contacted.
Okay, so I can email the court an order, or I mean,
Yeah.
it just, as long as the court is just aware of what's going on, so that the complainant won't come trying to say that my client violated or something.
So who's the prosecutor on that case?
Whoever the courtroom prosecutor was, not sure.
I think it was Nersettia.
Possibly, I don't remember.
Send me your email address. I'll send an order to both of you all.
Okay, thank you. Okay, have a good day, thank you.
You too.
I heard you, but I didn't pay attention. Once you get your confidence of his communications and how. So what I'm doing now, I'm doing, so I go here. Oh. Hearing is. Hey, Judge Sabree.
Oh, wait, slow down.
But on this,
Criminal
criminal
hearing.
responsibility, say date of hearing.
Oh,
of the
heart
judge,
rate.
is it-
Matter in a jackrabbit.
Gosh,
I didn't want you to run downstairs, though.
yeah, that was coming next. I thought about it, though. I thought about it. I thought about it. Especially when he turned around. I said, yeah. Yeah. I got two cases. That bell here.
Forensic Center. So now I'm going to transfer the information right here.
I'm straight.
It's right here, so I just.
This one here. He mad. He mad. Hey. Oh. All time no see. How you feeling?
I gotta go be a attorney line for 1 second. You know.
Yep. Judge,
Here it is.
on turn now, it's probably gonna be a dismissal. All we have right now is OIC.
Okay.
So it says not likely that they,
I take 10 o'clock, we'll have 10:30.
Pay attention, because tomorrow y'all.
three witnesses.
All right, so I got this done.
Prosecutor, come back up.
Hey, Watson, you want to get the phone, it's detention calling. When detention call, they want me to take the call, they want to speak to the officer. Oh, I got. Wait a minute. Herman's baby. I'll tell them to call you back, they both stepped down.
They both stepped down?
What's the number down here? What's your, I'll see you.
You see,
You're welcome. Bye. So, two of these you have to do, you already asked the judge. Sometimes you don't have to do criminal responsibility. I always just ask the judge, should I do it? And they'll tell me yes or no. When we go to the forensic, self-explanatory, and I'm gonna print it out, so the judge can sign it. Wait,
Tennessee right here, sir.
and then I gotta do, there's another one I need to do also.
Cheers.
And then we're gonna do the order of evaluation. That's the criminal responsibility. So come on, yes. This is the order for competency examination. So now I'm gonna take this one. Same thing. Just, give me that. What are you reading?
It's a book about being a veteran trial.
Oh.
And it's actually, it's one of the best books, may I approach?
Yeah.
It's one of the best books I've ever read on this. I read it every year. So, yeah. It's really, really helpful. You know, not since COVID, I've done
Yes.
one.
I like my glasses.
But I've literally since I did one in another jurisdiction, and then I've done one in Wayne County since March of. March 20. What about you? Do you do the new trials?
So when I was a traffic number, maybe.
I'll send this to you.
Four.
Okay.
I had two jury trials for 5 years.
Still didn't have to hear that.
I'm in my 6th year. I know.
Wow.
Then when I did the end of the jury trial, I'm like, well, let's do that. I'm so excited. Okay, you read her name.
That's okay.
My brain's not like, no. Wait.
Yeah, thank you so much.
Yeah, no problem.
So, Mr. Parnell, we'll take the names. What's your last name? Okay.
Can you pronounce your name again?
Zavion Parnell.
Zavion Parnell.
Zavion.
Zavion,
Yes,
okay.
ma'am.
Zavion.
Whenever you're ready. Okay, this is case number 2056228. The people of the state of Michigan versus Zavion, middle name Omariez, last name Parnell. He's charged with count 1, home invasion in the 1st degree, count 2, larceny in a building. And say they set for an exam appearances.
Good morning, Your Honor. APA Catherine Blackshire for the people, P84150.
Good morning, Your Honor. Nancy Casser from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Parnell, P number 80549.
Mr. Parnell, please state your full name for the record, please.
Name is Zavion Amarias Parnell.
All right, our parties ready to proceed.
The people are unable to proceed at this time, Your Honor. We did subpoena the complaining witnesses, and my OIC really went above and beyond to get in touch with them. They are not here today, and therefore we cannot proceed. Judge, with that, if that makes a motion, please stand.
Okay, time is 10:48. The exam is scheduled for 10:30. Seeing the people not ready to proceed, I will dismiss without prejudice.
Thank you, Judge.
I have a form.
Thank you, Your Honor.
Yep, take
The
this.
child. And we're going to child services and just going to keep.
One's gonna be-
I gotta get that, try to get the stuff that needs to be sent to the judge. So when you make
My bad.
this copy, and then make another copy, because it's
Oh, yeah, it's all right, sir.
prosecutor, one goes to the defense attorney, one goes to the defendant. So you just make it. Keep that good in. It's okay, because it was the defense. The defense asked for that. So I'm right now. So I take that downstairs. See you.
I didn't get it.
The judge has it. So where's all the copies? Oh, so this is what you give them in the original. Hold on to that. Here, Watson. I missed the whole.
These guys gotta have all the fun.
They got to have all the fun, I know.
Okay.
All right, thank you so much.
And one more thing, downstairs, y'all. I forgot to give you a message, they called you back.
Look at that now. Look at that.
Huh? I don't know, you gotta talk to the officer, they kind of busy right now. Okay. All right.
Call back again?
Do they wanna know, can you call them? They wanna know if. You gotta come back up. Oh, one. Hello, can I help you?
We were here.
No?
All right, thank you so much, guys.
Thank you.
Appreciate it.
Yeah, he's going to. Wait a minute. We did July. Did we do Martin?
No, we
No.
about to-
Oh, we about to do him now.
Yeah, I just want to get together.
Yeah. Yeah, they gotta log on to YouTube.
Mark,
Yeah, okay.
yeah.
So whenever there's someone trying to come for support, they're not allowed to come in the courtroom. They can log on to YouTube and watch the proceedings.
Oh, boy.
I got this done. Put the packet together. There's a packet you got to put together to send to the forensic center. Yeah. Here's the other.
Yeah, I guess you set an appointment. Martin, come on. Put your mask up. See right there.
Have you signed the file?
Waving on one of them, right? File back. There it is.
Calling case 2260962. The people of the state of Michigan versus Giovanni Ethan Eli Martin. Defendant is charged with count 1, jail's possession of weapon in. Count 2, malicious destruction of building less than $200. Also calling case 2355221. The people of the state of Michigan versus Giovanni Ethan Eli Martin. Defendant is charged with carjacking. Today is set for exam on both matters.
Good morning, Your Honor. APA Catherine Waxer, 84150.
And Judge, good morning to you and to your staff. Good morning. Michael Woodyard, my P number is 64612. I'm with Neighborhood Defender Service of Detroit. We represent Mr. Giovanni Martin. He's here in court. Say your name and say good morning, sir.
My name is Giovanni Eli Martin. Good morning.
Good morning. I know this case in any particular order.
I can tell you that the one about the jail, that is, the people are moving to dismiss for improper venue.
No objection.
Okay. That would be case in 2.
Can you say the whole case number, Judge?
Sure.
Please?
22600962.
Thank you.
I will dismiss that case. Would it be, it's without prejudice?
Without prejudice, Judge, thank you.
Okay, and then we have left here case number 2355221, the one count of carjacking. How are we moving forward on this case?
The people are ready to proceed.
And Judge, as it relates to the carjacking allegation, I have had an opportunity to speak with Mr. Martin about preliminary examination, the responsibilities the prosecutor shoulders during that hearing, what our role is, and the decision the court might make after hearing evidence. Knowing all of that, I believe Mr. Martin is prepared to waive his right to an exam, and I would offer him to the court for your watching.
Mr. Martin, is that correct? You'd like to waive your preliminary exam today?
Yes, ma'am.
You have a right to a preliminary exam?
Yes, ma'am.
And do you also understand that the people, if you oppose that exam, they would have to prove that the probable cause standard, not the beyond a reasonable doubt standard, but probable cause standard, that one kind of carjacking was committed in the city of Detroit and you probably committed that crime. You understand that?
Yes, ma'am.
And then by waiving your preliminary exam, that means that the people do not have to prove that to them.
Yes.
Knowing that information, do you still wish to waive your preliminary exam?
Yes, ma'am.
Okay, a couple more questions. Did anyone force you or threaten you to waive your exam today?
No, ma'am.
Did anyone promise you anything to waive your exam?
No, ma'am.
Okay, I find your waiver to be freely, understandably, and voluntarily given. So I'll have you bound over to Third Circuit Court, that's right, on the Hall of Justice, for a regular information of February 21st at 9 a.m. Okay?
Thank you.
Judge, before Mr. Martin departs, can I address the question of bond?
Yes.
Your Honor, Mr. Martin's bond, I think currently stands at, if I'm not mistaken, $350,000 cash.
Yes.
It is. Okay.
And Judge, that is a bond that is for Mr. Martin and for me and for many others. So tantamount to remand. Of course, Mr. Martin enjoys a constitutional right to a reasonable bond in these cases. In this case, I would point out that now Mr. Martin stands before you with only the one matter pending. Mr. Martin is an 18-year-old young man. He was in his final year of high school when these allegations arose. And if he's afforded a bond, we would certainly be fine with the GPS tether. He would live either with his dad in Southfield or with his mom in the city of Detroit. Either one are prepared to welcome Mr. Martin into their homes. And we would ask you to lower the bond, perhaps to $100,000, 10%.
Anything with people?
Yes, Judge, the people would oppose any change to the bond. This is a very serious case, carjacking. The allegations that the people will prove at trial and would have proved that exam is that the defendant attacked a woman in broad daylight at a public gas station. We have it all on video. Punched her. She fell to the ground, grabbed her keys, and stole her car. This is not the sort of individual that we want walking the streets of Detroit, even with the tether. So the people would move for no change. If the court is inclined to make a change, the people would ask for higher than 100,000, 10%, maybe 200,000 or 250, 10% with a tether and with a house arrest, restriction in place, unless the defendant is, physically at school, if he attends school in person. If he attends school via, virtual school, then the house arrest, the people would ask for a house arrest provision. Thank you.
But he was enrolled at Henry Ford High School at the time of this incident. Of course, he's been incarcerated since he was arrested.
I only ask that because I'm only inclined, I'm changing the bond to him being on house arrest.
And Mr. Martin recognizes that is an option that the court has, and he would not.
So I will adjust your bond, and I am going to raise it. Let's see. The cash amount for the amount. 350. 350,000 now.
Yes, ma'am, cash.
Okay, I'm gonna leave it 350,000. Personal, have to be very specific on your tether, house arrest. No exceptions. And then I need address.